welcome back to the Attorney Tom. I don't even know what this is, but
Arby's was sued.
Tom is obsessed with Arby's. We know this, and he's back doing content again.
I, as a connoisseur of fast food, I just don't like it when the entire fast food industry is brought down by Arby's, because I think it's disgusting.
Yeah. Have you eaten there before?
Yes, it's been a long time.
Okay. We don't think he's eaten there. We think it's a conspiracy we have in the office. It's very strange. Tom's behavior is very strange.
This is Melissa Nelson, individually and on behalf of all others similarly situated, meaning she's trying to get class certification. Yep. Versus Arby's Restaurant Group Incorporated. Again, filed in the Supreme Court, State of New York, County of Queens. So filed in Queens, New York. One step removed from shrinkflation is greedflation, where a company raises prices beyond what is necessary to account for rising prices, selling what appears to be similar quantities or amounts of product to the public. What do you think about that? Greedflation.
I mean, I don't doubt that that's a real thing. I feel like proving that, especially in the fast food industry where variance is so... again, I don't even know.
Well, let's read.
Most of the words
based on information and belief and investigation of counsel. 1. Has resized its French fries so that the kid size was now small, shown below. The small became medium, and the medium became large, without any correspondence reduction in price, and or without conspicuous or any disclosure to its consumers, and such allegations are likely to have support following the opportunity for reasonable discovery. So what they're saying is the small size, kid size became the small size, medium. Wait, my brain hurts. What they're saying.
I think we all
get it. All the sizes got moved down. The large fries don't exist anymore. The new large fries are formerly the medium fries.
Which, aside from a lawsuit, I think people eating Arby's, they could benefit from this just in general.
Yeah, no, I actually agree with that. I think this is a net positive.
Yeah, I don't know if they should have charged as much for them, but I mean, people that if you're eating Arby's, you do need to eat less food. I think that's a
good. So look, we're looking at the fries here. We have a little bit of chart that they're showing how they've just skewed everything over. But what statute? Here's what I want to know. This is I'm gonna skip. I'm going to the causes of action. That's what I want to see. Causes of action: General Business Law, Section 349 and 350. To the extent required, this section incorporates by reference any other paragraphs as necessary. The purpose of the GBL is to protect consumers against unfair and deceptive practices. The GBL was intentionally brought to encompass methods of deception which could not be conceived at the time it was enacted. So the GBL sounds like New York's version of deceptive trade practice, like the DTPA in Texas. It is purposely broad because you can't enumerate, you can't make a law that says Arby's cannot change the size of their fries and then rename it and shrinkflation it. You can't specifically enumerate all of these little things. So
I think the big thing here is the purposeful deception, because they are allowed to, but if they change it and they still call it the same thing, and just
that's right.
3 weeks ago a large is now different.
That's right.
Same price. That is deceptive, right?
Right. I mean that would be the argument, because somebody goes to Arby's regularly and they get a large. A large is a large is a large. They're paying the same amount. But then suddenly, without getting notice, it's not illegal to change your portions per se, but what does the consumer believe they're getting?
Yeah, and that's what Melissa's arguing, huh?
Yeah. Plaintiff paid more than she would have paid had she known she was buying a smaller quantity of French fries and beverages, but not at a proportionally lower price. That is the deal.
All right, let's
go. Let's keep one of the other causes of action.
Go up. I want to see what she's. No. You're right there. Okay, what she's trying to recover.
Plaintiff seeks to recover economic injury and/or the loss she sustained. So, I mean that look.
She's doing this out of principle.
Yeah, I mean, let's call a spade a spade. And by the way, this is actually a serious topic. Her actual economic injury is probably just a few dollars. But she's trying to get class certification, meaning she's trying to represent not only herself, but the entire class of individuals who are harmed. At first blush, this is where the trolls come out and they say, oh, greedy class action lawyers. What good does this serve? This lady lost a couple dollars. She's going to sue, and Arby's is going to have to defend this frivolous lawsuit, blah, blah, blah. It could not be further from the truth. When you sue as a class action, you're basically acting as a private attorney general. You're preventing these sort of mini scams from happening. Because if I was a company and I knew that if I didn't make it economically viable for somebody to sue me, I would just nickel and dime scam people to death. Scam people to death. Because you're not going to go. The reality is, these lawyers, nobody's going to go hire a lawyer for $900, $1,200 an hour to go prosecute this case, to go get your $7 back. But if the lawyers have a vehicle where they can act on behalf of all consumers, take on the risk themselves, mean front their time, expenses, effort into the case, sue on behalf of all of the affected consumers, and then take a percentage of what they recover, which is generally 25 to 33% on class actions, just depends on what the court approves, then it's a win for everybody. For any more trolls out there, you should read a book. It's called The Conservative Case for Class Actions. It's written by, I forget his name, but I met him at the American Antitrust Institution. He was a speaker there. He's not a member there because he probably disagrees with the AAI. The thesis of that book is class actions are great. There's a direct correlation between economic productivity and litigiousness of the marketplace. Why? Because
You have
companies,
to hold these greedy companies accountable.
right? Because companies know they can't put out bad products into the marketplace, or they will be sued. This can be a long video. All right. So I think there's only one cause of action: general business law. So it's a state-specific claim. So they're not trying to sue on a nationwide class. They're not trying to get everybody who is affected by this across the country. It sounds like it's just consumers in New York. And maybe we can go find the class definition down here. Okay, here we go. The following class is what I was looking for. All persons in New York who purchased French fries and beverages at Arby's in New York who had previously purchased French fries and beverages before sizes were adjusted downwards during the statute of limitations for each cause of action. Yeah. So this is, like I thought, a pretty narrow class. They're not going for nationwide classes. This isn't just every person who's ever been to Arby's ever. These are people in New York who have bought these products, who had previously bought these products. So like for me, if I went to Arby's and I bought these products, I would not be part of this class because I had not purchased Arby's in New York in the relevant statute of limitations. Right? Interesting. I like the case. I'm obviously biased. I don't know if this was a case that my law firm would do. It seems kind of on the smaller end of what EKSM would handle for a lot of reasons. I mean, not just that the case is small, but obviously it being in New York, I'm probably conflicted out because of Arby's. No, I'm not actually conflicted out, but you get the point. So there you go. So there's one case. Should we talk about the other case?
What is the other one?
So that one was the shrinkflation.
Yeah, shrinkflation.
The other one is false advertising, which is similar, which goes into the...
This one, yeah, we can talk about this one real quick, I think.
Yeah. So hold on, let's figure out where this case is filed. Also in the Eastern District of New York. I wonder if this is the same lawyers. Hold on, I'm going to go down. Anthony Russo. Nope, different lawyers. Arby's is catching strays from a bunch of people. I mean, what do you think about this?
So, the idea is just that...
Does it offend you?
Explained, that food does look disgusting. But explain the false advertising to us.
All right, well, let's take it from the factual allegations. This is a class action against Arby's for unfair deceptive trade practices for selling overstated menu items based on materially false and misleading advertisements concerning the amount and quality of the meat contained therein. So amount
this person
and quality.
Sounds like they might join the class on the other shrinkflation for the amount.
Arby's uses photographs in its advertisements that make it appear that the overstated menu items contain approximately 100% more meat than what the actual sandwiches do. Arby's does this by placing all of the meat in a sandwich used for a photo shoot to the front of the sandwich and positioning the meat with props so that it appears to be much larger in size than the actual sandwich provided to customers. Arby's also deceptively misrepresents the quality of its roast beef in its advertisements for the overstated menu items, that it shows that the meat as rare roast beef in its advertisements when the roast beef regularly served to customers is not rare roast beef. For example, Arby's advertisement for the classic roast beef sandwich looks as follows when compared to the actual item provided. So what Arby's will say, hey, it's the same amount of meat, but as we have learned from the allegation, allegedly, that it might technically be the same amount of meat, but that's some trickery by positioning it up to the front.
I wish you could sue. I mean, I guess they said rare because it does look like it's a little rare, but I wish they could sue and just, I know this isn't lawyery, but if you just said, hey, it just actually is pretty gross. This is just bad food. But then I guess like White Castle's getting sued.
Everybody's getting sued.
Yeah, Long
I
John
mean, let's be
Silver's.
real.
I mean, that looks, I don't even like to look at that. Is that bread? Oh, that's the bread. Wow, that is a lot less meat.
Yeah.
I thought that was cheese.
Well, what Arby's would say, it's the same amount of meat, but
Yeah, just-
I mean, if we can just peel back the fourth
Curtain.
wall, the curtain, the beef curtain.
Yeah, can't say that probably. I think that's slang for females' privates.
No.
I don't know if that's the brand you're going for there. Look who's the lawyer now. Look who's the PR specialist. Double beef and cheddar.
Honestly, the left looks just as disgusting as the right.
I
honestly don't see any difference.
I don't think so. I think if you got that one on the left, you'd think that's okay. The one on the right, though, what even is that? What's on the bun? Half-pound beef and cheddar. Golly. I wonder how many people have eaten that half-pound beef and cheddar and are still, like, alive. I'm not saying they died
I mean, that
from
does
it.
look ginormous. I mean,
I'm not saying they died from it, but I'm saying they didn't live.
No,
from
what
it.
you're suggesting is the people who eat a half-pound beef and cheddar, maybe Arby's is not the sole cause,
Yeah.
but
There are other comorbidities. There are
Right.
other comorbidities.
that led them there.
You're
I
doing
agree.
A lot of bad stuff.
That's
That
like
one
flossing
doesn't-
your teeth.
That one doesn't look
When people
bad.
say flossing your teeth prevents heart attacks because people who floss their teeth don't get heart attacks. But in reality, people who floss their teeth are also health nerds who probably do 20 other things.
Yes. It's like when they said, like, they do, like, the red meat study, and they're like, well, red meat's bad for you. And then they go, well, what red meat are you eating? Are you eating McDonald's?
Yeah,
Or
or
are
a
you
filet
eating
mignon.
a grass-fed steak?
Right.
Yeah. It's a little different, I think.
All right, so on August 3rd, 2023, plaintiff purchased double beef and cheese from New York, $7.69. During the same visit, plaintiff also purchased a smokehouse brisket sandwich. So this person bought a double beef and cheddar and a smokehouse beef in one sitting. They were hungry.
Well, they may have been with a guest.
That is true. But I mean, do you bring a guest to Arby's?
I don't think they call them guests. I think they call them inmates. I think that's what they call them. Oh, there we go. Oh.
Ambulance?
I thought he was doing, because I said inmates. I thought he was doing a red and blue.
Press the wrong button.
There we go.
Ambulance.
Yeah. Because inmates.
Yeah.
Okay. All right.
All right,
I think
wait,
we're about
well,
wrapped up.
I mean, I want to look at. Well, dude, hold on. This is important.
Derek, you're going to have to work your magic on this one.
Why don't we use the board? The whiteboard is.
Well, let's get.
No, we don't need to use the whiteboard.
Here's the class allegations. All persons or entities that purchase a classic roast beef, double roast beef, half-pound roast beef, classic beef and cheddar, double beef and cheddar, half-pound beef and cheddar, and or smokehouse brisket menu item from Arby's located in the state of New York during the period between September 5th, 2020 through the date of final disposition of this action. This is great. I support, just because you filed a case doesn't mean you're going to win, but I support it. I will help out if I'm called upon.
Yeah.
Although I'm not licensed in New York, so I'd have to pro hawk it. Let's see the causes of action. Count 1, deceptive acts and practices. New York General Business Law 349, which we learned from the previous lawsuit. 350, again, which is what we've learned from the previous lawsuit. Breach of contract, interesting. Plaintiff incorporates by reference the allegations every paragraph of his complaint. Defendant, through its advertising in its store and online, offered overstated menu items based on materially false and misleading advertisements described above. Plaintiff and numerous other consumers purchased said overstated menu items based on defendant's representations. Defendants breach its sales contracts with plaintiffs and similarly situated customers who purchased an overstated menu item. I love it. Unjust enrichment. Love it. Love it. We're suing Honey for an unjust enrichment claim. This is great. I support this. I don't know what's going on in this case. I just wanted to let the public know that this is happening. I can't tell you whether it's true or not. Can't tell you that. What I can tell you is there are allegations.
There are allegations. Thank you guys for tuning in to the Attorney Tom.
I think we should. Do you want to refilm it? Start over.
This whole video?
Yeah.
Tom?
I think we should refilm it.
Whoa. I have a headache. I have a genuine headache because we're not supplied water here. You did a good job explaining it. And Dirk's going to shorten it up a little bit. Get out some of the bad stuff. Castro, shut your...
If anybody's listening to this right now, it means that Dirk has put
too much in.
too much in.
Yeah.
I think
All
we
right,
should-
just guys, let's just cut it.
Okay.